rise. The Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. We're here today for oral argument in the case of Mark MURRO versus the Arizona Department of Health Services, Court of Appeals number CA-CV18-0471. Thank you all for coming. We have reviewed your briefs. We have conferenced the case this morning. So we're pretty familiar with the facts. Please keep that in mind when you make your arguments. Each side is allocated 20 minutes. Appellant, if you want to reserve some time, you may do so, but it's up to you to keep track of your time and do that. I think that's it. Oh, we record everything here for YouTube. I don't know why anyone would want to watch it, but in case it's available if they do, or if you want to go back and look at it. But because of that, please make sure that you state your name clearly and who you represent when you begin, so that people watching online can figure out who everyone is.
I think I don't know why anyone would want to watch it as YouTube's slogans. You may be surprised.
I looked once, and I think I had one view for one of my arguments, which was probably me. Anyway, we can begin now. So, appellant, please proceed.
I know that you've all read the brief, and so rather than kind of recap what my basic argument is, which I think is pretty plain and straightforward, I did want to just touch on a couple things that maybe I didn't really fully address in that brief. First of all, the review, to start out with, though, the review here I think is clearly de novo. This is a strictly legal question of statutory interpretation. Because it's de novo, the lower court decision and the ALJ's decision really wouldn't be pertinent, nor would be the department's initial opinion in this matter under the ARS 12-910E, which precludes the reviewing court from considering, or deferring to, I should say, agency interpretation. That statute has been in effect now for several months, since I believe August of 2018, and so clearly would apply to the court's consideration today. So unlike in many of the federal cases that the department cites, which include a Chevron doctrine analysis, deferring to the, for example, Board of Immigration Appeals or United States Sentencing Commission, that would not be appropriate in this case to defer to the Department of Health Services. The body of case law that the department relies on, I have found, can really be divided into about 5 different categories, all of which are not really pertinent to the issue at hand. Some of the cases are more than one category applies. One of the more interesting categories is the prevalence in the department's brief in relying on cases analyzing statutes. These are federal cases that define things like controlled substance offense or drug trafficking offense to be anything that relates to any commission of an offense that relates to a controlled substance. So any crime that touched upon a controlled substance, regardless of whether it could be considered a controlled substance itself, would be considered to meet the definition. I think that's actually what those examples of those cases would be United States versus Mesa Corrales, Gold versus Attorney General of the United States, Peters v. Ashcroft, Milowitz, I know I'm butchering that one, v. Holder, so several of the department's cases. And that's really actually what the department, the thrust of their argument is what they're asking you to do, is to agree with them that this statute should be interpreted in that way, to be broadened beyond the specific explicit language in the statute to include anything that could relate to a controlled substances offense. And that appears several times that kind of language appears several times in the department's argument. It talks about any felony conviction related to a controlled substance, page 12 and 21, or relating to, page 19, or related specifically to, page 21, or involving or involved, page 18, 22, and 23, a controlled substance. But
How would
that's-
you have us define a controlled substance law? Because that seems to be the statutory phrase that's at issue here, really.
Yes, yeah, a violation of a controlled substance law. Fortunately, we have a clear section in the criminal code that categorizes what offenses it would consider to be controlled substance offenses, which is a completely separate category than the category of preparatory offenses, which is it's like the solicitation that we're dealing here with today.
If I understand you correctly, one could, if your argument succeeded, one could continue to commit solicitation on an ongoing basis and still retain the status.
Or conspiracy, or attempt, or any of the other offenses.
Yeah, I think that unless it actually it rose to the level of being an accomplice, of course, then they would be committing the actual substantive offense. So I think a drug lord analogy that the department brought up, but what could do these drug lords? Well, typically, I think you would find that they were also involved in participating to some extent as accomplices, aiding and abetting the commission of the crime, and therefore could be convicted of the crime if the state chose to attempt, to prosecute them.
You
What
see
about
that-
conspiracy, though? In your argument, conspiracy wouldn't qualify.
Well, I mean, I think that we need to look at the preparatory offenses as a whole. If the state chooses to charge someone or convict someone of conspiracy as opposed to an actual controlled substance offense, then, and that's their prerogative, but I think they have to take into consideration that by convicting someone simply of a preparatory offense, there's a lot of consequences that follow from that. You can't sentence them the same way. Several other issues that the courts here in Arizona have clearly said preparatory offenses have to be treated differently. So when you are charging someone or convicting someone or doing a plea deal, bear that in mind, because there could be collateral consequences that are very different depending on whether it's a substantive offense or the inchoate offense. So I think that while you could say it's logically possible for someone to commit, say, solicitation several times without actually committing the substantive offense, I think that's highly unlikely that would occur that way. But I suppose it is a possibility. But it's different. I mean, it's solicitation. It's not a controlled substance law.
And isn't the punishment for solicitation determined by relation to the drug crime?
It's not, no. It's actually, I think, well,
If I remember, isn't it like two
Oh,
classes below
yeah.
the
I'm sorry.
substantive crime?
I'm sorry, you're right. I didn't understand what you meant. That's true. So it defers to the level felony solicitation to.
Sentence for solicitation without reference to the substantive crime that's involved.
That's right. Because solicitation is just a generic offense. It doesn't carry any felony level in and of itself.
Actually, there is no real just generic offense of solicitation, is there?
Well, in the sense that it does refer to, it has to refer to, and that was one of the cases, I think Portillo, that the department cited in their brief, talked about you can't just convict someone for just solicitation. It has to be solicitation to do something. But to solicit to do something in no way means that you actually did it. So the question becomes, if solicitation doesn't require the commission of a controlled substance offense, then how can it be considered a controlled substance?
But the statute doesn't say controlled substance offense. It says controlled substance law.
Yeah, the violation of a controlled substance law.
Right.
And you won't find
So your argument that you could commit solicitation without committing the actual offense isn't really directly on point. It's really, you have to relate to, or at least, and I understand your argument regarding relate to being too broad, but it is a violation of solicitation to violate this law.
Well, okay, if it's just relate to, then we...
No, I'm back. I walk that back.
Okay,
It's
okay.
solicitation to violate the
Yeah.
controlled substance law. It's not to commit the actual offense.
So, for example, someone here is a medical marijuana patient, say, and says to another medical marijuana patient, could I buy some of your marijuana? Not knowing that they're not allowed to do that, and the other patient says, well, I can't, that's illegal. Oh, it is? I didn't know, sorry. But too late. Now that person is now tagged with having committed a controlled substance offense. But I think that doesn't, I mean, nobody would think that would really be a controlled substance offense. It's a simple question asked out of ignorance, but that would provide a factual basis for solicitation to commit a controlled substance offense or to violate a controlled substance law.
So ignorance of the law should be an excuse in that case.
No, I'm not saying ignorance of the law is exactly why it would be solicitation. It would, the lack of mistake of law isn't a defense, so it would be, even that innocent scenario would be, in fact, solicitation to commit a controlled substance offense.
Couldn't the drafters of this statute of the AMMA done what federal law did and say, these inchoate offenses are excluded and this one's not?
Well, interestingly, you're right. That's what some of the federal statutes do, is they list preparatory offenses, certain preparatory offenses, and then most of the federal case law that's looked at that has said that once they've listed some inchoate offenses, they've indicated their intent to include inchoate offenses in general, even if they might not have specifically.
Or the Ninth Circuit found the opposite, and actually found the listing of some means they intended to exclude the others.
Well, yeah, but that decision goes farther than that, though, Judge. That decision talks about, looks at Arizona's specific solicitation statute as different in kind from, for example, Oregon's solicitation statute, which is not in a separate body of law, but so in Oregon, the Ninth Circuit would consider that solicitation to be a drug offense versus the one in Arizona, because of the way they're written differently, and they're contained in separate classifications, separate categories of law, unlike, for example, in Oregon, I believe also in California, although we don't have the benefit of a California case on point in the briefs. So did I answer your question?
I think so.
Okay.
So what kind of, if it's not a controlled substance law, what kind of law is solicitation?
It's a preparatory offense. That's what the title is.
I thought you were going to say that, but if
Yeah.
if one were convicted then of solicitation to commit murder, still okay?
Well,
Not a problem under this statute?
I think it's similar. There's the other category of excluded felony offense, which is what we're talking about here under the Medical Marijuana Act, is a crime of violence, which is a lifetime bar. And so,
But it's only solicitation.
right. So that murder clearly would be an excluded felony offense.
Right.
Solicitation to commit murder, I don't think would be.
How about
So-
conspiracy to commit murder?
I think you have to keep all of these in the same category because none of them require the actual commission of a substantive offense. To say that a person who merely requested or encouraged, but falling short of actually being an accomplice in the case, has not committed a violent crime. Has just simply not committed a violent crime, unless their conduct rises to the level of being an accomplice, in which case the state is free to charge them for the substantive offense if they can prove it.
I haven't thought about this, so maybe I don't want to take too much of your time, but you keep referencing accomplice and accomplice liability. Isn't accomplice liability under Arizona law contained in a different statute too?
Yeah.
Different section?
Yes.
So why would you be so quick to say, well, accomplices would still be guilty, but not solicitors?
Only because it specifically says that you are committing the substantive offense, and
I think it says shall be punished the same.
shall be punished as if they committed the offense themselves. But I think it's because their conduct rises to a level to be an accomplice. The conduct.
What's the difference between solicitation and accomplice? Accomplice is someone who aids, encourages, etc.
Yeah.
Solicitation is someone who asks, encourages.
that a crime actually has to be committed?
So the completion of the crime.
Completion of the
But
crime.
someone else could complete the crime. It doesn't have to be the person who actually did it.
Yeah, but a crime nonetheless has to be committed.
Actually commit the crime, which is your argument.
He
about-
helped.
And conspiracy doesn't require the completion of the crime.
No, because it's it's a preparatory. It means just preparing, not completing.
So your position is that conspiracy is okay too?
I think you would have to say anything that isn't an actually a completed controlled substance violation is not a controlled substance violation. It might be preparing to commit one.
So you could disclose. I just did a 15-year term for conspiracy to commit murder. I'd like to be certified now, and that's okay.
I think you could argue that I never committed murder. I never committed a violent offense. I engaged in activity, none of which was remotely related to violence. I didn't commit any violence, and no one else committed any violence. No one died. No one died. What?
Why would you say that?
Because in a conspiracy, it doesn't require the completed crime. There's just an agreement among.
But that doesn't necessarily mean that someone didn't die. You could conspire to commit murder, and they actually commit the murder, and you did just the payment of it.
It could, Judge, but at that point, I guess I'm saying that that person could be convicted as an accomplice, of the completed crime. If the state.
We don't look you're not encouraging us to look at the underlying facts. Like if we looked at the underlying facts in your client's case, there probably was a completed crime.
Well, that would be what's called a categorical approach, and
Right.
some of the cases that the department relies on do just that, and that's how they reached their conclusion.
Well, no, but I'm saying we don't do that. You seem to be saying,
Right.
well, he come out and say no one actually died. The truth is probably someone did die, and your client probably sold marijuana, but that's not what we're here about. We're just looking at the nature of the crime he actually pled to.
The substance in question was not marijuana, but testosterone.
Right. Yeah. Dangerous drugs, I'm sorry.
Yeah, testosterone in particular. So we, I think that though that is a fundamental distinction. When you're talking about saying, did this person violate a controlled substance law, then you better have a completed crime. And sure, there may be cases where the state has pled down, from a completed crime charge to but if they've chosen to do that, that decision has consequences. And we're looking at the four corners. There's no evidence here of specific facts, none in the record, Judge, of specific facts about this crime. And nor would it be appropriate to look behind the four corners of the statute, solicitation. And I think if you do that, you've got certainly nothing requiring that any crime was ever committed, any actual crime, substantive crime, was ever completed. There's no requirement. And if there's no requirement that any substantive crime be completed, I don't think that you can logically conclude that a controlled substance law has been violated. That's basically the thrust of my argument. And I know that it's tempting to say, well, let's just say anything that relates to a controlled substance, but that's not what the law says. Unlike some of these federal cases that do list out preparatory offenses. They might exclude solicitation, but it's a broad enough list of where the court decides it's appropriate to also include solicitation.
What law did your client violate that led to his plea?
The law, what law did he violate? Well, to soliciting the possession of a dangerous drug, to wit, testosterone.
That's not a law. I mean, that your whole argument is based on the notion that solicitation is a separate law.
Right.
So what law did your client violate?
He violated the law that says that you're not allowed to request or solicit or encourage someone else to engage in illegal conduct.
In illegal conduct.
In this case, engage in what is a
So
controlled.
this gets back to your argument then that it doesn't matter what you solicit. Basically, any solicitation conviction for any underlying offense doesn't count for this purpose.
Yeah, that is. I think logically that has to be the conclusion. To reach a different result, you have to add in language to what the statute. It doesn't say relating to or involving a controlled substance.
If we looked at his plea agreement or his judgment of conviction, it would say 1002, right?
It would say, well, it's in the state's brief. They actually list
1002, and it also says 3408, 34.
It has to, according to Portillo, because you have to reference.
In order to figure out what crime he solicited, you have to know the elements and have met the elements of the underlying crime as well, right?
That there was an intent to commit the underlying crime. Yes, not that it was committed, but just that there was an intent to commit it. Okay. And that's why the elements are relevant, only because of the requirement of the mental state to commit it. But it doesn't in any way require it to be actually committed.
Right.
So without that, how's there a violation of a controlled substance law, I guess is my point. There's a 15. Okay, Judge, if I could, I'd like to reserve 5 minutes of my time at this point. Thank you.
Good morning.
Morning.
My name is Matt Hesketh. With me is Gregory Falls. We're here on behalf of the Arizona Department of Health Services. I want to address just a few points that were brought up with Mr. Dean. First, there was the issue of violent crimes and whether solicitation to commit murder or possibly solicitation to commit some other violent crime would constitute an excluded felony offense. I think there's a potential distinction to be drawn between a controlled substance excluded felony offense and a violent crime excluded felony offense, because the definition of a violent crime involves the use of a deadly weapon or dangerous instrument or a criminal act that results in physical injury or death. That's focusing really on the actus reus, as opposed to the entire crime which includes the mens res. As Mr. Dean pointed out, the law in Arizona, and this is demonstrated in the Portillo case, and it's also discussed by the Second Circuit in the Mizrahi case, the entire crime of solicitation includes both the actus reus and the mens reus. And the underlying substantive offense is required, it's a part of the crime, in order to complete the definition of solicitation.
But the crime does not have to be completed in order to be guilty of solicitation.
That is true, but there's also nothing in the definition of an excluded felony offense that says that it has to be a completed crime. What we're looking for is a violation of controlled substance law. Mr. Murro's conduct would not be a crime but for controlled substance law. If you were to remove Chapter 34 from Title 13, eliminate the drug laws entirely, he would have not committed a crime in this case. If Arizona has no drug laws, his solicitation would not be illegal in this case. It is only...
By the same token, if you remove the solicitation statute, which is not a subject matter specific statute, he also would have committed no crime.
That is true, but the point is you need both laws in order to define the complete crime of solicitation.
But yet the statute we're here concerned with today only mentions one law. It doesn't mention both.
Are you talking about the solicitation statute or the excluded felony offense statute?
The excluded felony offense statute. That doesn't say, look at all of the relevant laws. It says, did you violate controlled substance law?
And I think the answer is yes. He necessarily had to have...
Although if you left the controlled substances laws exactly as they were, but repealed the solicitation statute, which has nothing to do with controlled substances, he would not have committed a crime at all.
That's true.
So, I mean, are you effectively arguing against your own position here?
I don't believe so, because all you need is a violation of a controlled substance law. It doesn't say you need a completed controlled substance violation. It doesn't say you need to have violated the substantive controlled substance law. The definition of his crime isn't complete without reference to a controlled substance law. By defining solicitation in a generic statute, the Arizona legislature chose to incorporate the rest of the criminal code in order to complete the definition of solicitation in a particular instance. The Second Circuit pointed out in the Mizrahi case that the legislature just as easily could have included a different subsection for each substantive offense within the solicitation statute. Or, alternatively, the legislature could have included a solicitation subpart within each substantive offense. But as Judge Swan pointed out in the earlier oral argument, we don't want criminal laws, or laws in general, with a bunch of subparts. So instead, the legislature chose the more efficient matter of legislative drafting, and by doing so, it necessarily incorporates other law in order to complete the definition of solicitation in a particular instance. The Second Circuit explained that the effect of that is the same. Whether you define solicitation by including a bunch of subparts of substantive offenses within the solicitation statute, whether you include a solicitation subpart within the rest of the substantive statutes, or whether you incorporate by reference the rest of the criminal code, the effect is the same. Going back to a point that Judge Morse, that Judge Morse raised, the conviction at issue states it is the judgment of the court that defendant is guilty of the following: solicitation to commit possession of dangerous drugs for sale. The name of the offense expressly includes possession of dangerous drugs for sale.
Well, who named the offense?
I suppose the state in the first instance, and then that carried forward.
The prosecutor named the offense, not the legislature.
But that's what he admitted, or what he pleaded guilty to.
Right, but they could have used any imprecise description they wanted, so long as they cite the right statutes. It's a valid conviction. I don't think the draftsmanship of the prosecutor should be our touchstone for what offense the defendant is convicted of. The touchstone is the statutes.
But solicitation can't be defined generically based on undefined criminal conduct, and this is the point of this court's holding in Portillo.
Well, in other words, they could have as easily said solicitation to violate ARS 13 blah, 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 right?
I agree with you. I agree.
And they wouldn't need that descriptive type.
Right, but you have to tie the solicitation offense to underlying criminal conduct. Otherwise, you cannot have a conviction for solicitation. This is the holding in Portillo. Solicitation cannot be defined as a generic crime. It must be defined in reference to some underlying substantive act. Based on nearly identical language, and as Judge Morse pointed out, the conviction also lists the solicitation statute 13-1002 as well as the drug offense definition statute 13-3401 and the particular offense at issue here, possession of dangerous drugs for sale, which is outlawed under 13-3407. All of those statutory references are included as part of the conviction. Based on nearly identical language in an Arizona conviction, the Fifth Circuit concluded in the Peters case that this on its face constitutes a violation of law related to a controlled substance. Now, Mr. MURRO argues that there's a difference between a law related to a controlled substance and a controlled substance law. We submit that that is a semantical distinction without any meaning. It's splitting hairs at such a microscopic level that there ceases to be any meaningful difference. AMA does not define controlled substance law. It doesn't say what that is. But a law related to a controlled substance seems like a good working definition. There's nothing criminal in the abstract about solicitation. People engaged in commerce go around soliciting goods and service all the time without committing crimes. It is only in reference to an underlying substantive offense that you have a complete crime. In this case, it was controlled substance law that made solicitation, Mr. MURRO's act of solicitation, a crime. And we can see that in two ways. If you remove the controlled substance from the factual equation, if the object of his solicitation was something legal instead of dangerous drugs for sale, we wouldn't have a crime. If, for example, he had solicited to possess protein powder for sale instead of testosterone for sale, we wouldn't have a crime. It is only because the object of his solicitation was a dangerous drug, which is illegal based on controlled substance law, that you have a crime. And then, as I mentioned earlier, his solicitation would not have been a crime without the substantive law. But for the controlled substance law, you don't have a crime in this case. It's the controlled substance law that provides the mens rea element that completes the full definition of the crime.
Counsel, was it necessary that MURRO lied in his application for this action to have been sustained?
No, Your Honor. There are two independent bases for the department's revocation in this case.
So why is there some greater sanction if they prove that he lied?
It's not necessarily lying. It's a knowing violation of AMA. And the department submits that Mr. MURRO knowingly violated AMA in two ways. One, the false attestation, which I think is what you're referring to, and also the fact that he acted as a dispensary agent when he wasn't qualified.
Just removed him from this business by showing that he had been convicted of the crime.
There is a further consequence for having a card revoked based on a knowing violation, as opposed to simply having a card revoked for some unknown reason. And that is the department. I'm sorry?
A fine or something?
No, the department would, in that instance, have the discretionary authority to deny future applications based on the revocation for a knowing violation.
Well, could he ever be licensed with this criminal conviction?
After 10 years.
He could after 10 years, after completing the punishment. In this case, it was probation, which he completed in, I believe, 2011. So we're still a few years away from the 10-year exception. If there's a finding, if there's a revocation based on a finding that he knowingly violated AMA, then the department would have the discretionary authority in the future to deny future applications, irrespective of the excluded felony offense issue.
But we don't seem to be talking about MURRO's state of mind when he applied. Is this not up not up before us?
I don't believe that particular issue is, Your Honor, because I believe Mr. Murrow's only argument in relation to that second basis for revocation is that he simply didn't have an excluded felony offense. So what he said in his attestation wasn't incorrect, and he didn't unlawfully act as a dispensary agent because he wasn't restricted from being one. I think that his argument related to that second basis collapses is basically just a carryover from his argument on the first basis, which is that he didn't have an excluded felony offense. I don't think he offers any additional argument with respect to that basis for revocation. I also want to point out that the legislature codified the nexus between solicitation and the underlying offense in the solicitation statute in 3 separate ways. First, there must be intent related to an underlying crime. 2, the defendant must solicit specific conduct related to that crime. And 3, the criminal classification level, and this is what Judge Thompson pointed out earlier, is based on the underlying crime. So in this case, Mr. Murrow was convicted of a Class 4 felony because possession of dangerous drugs for sale is a Class 2 felony. That last point is important because the classification scheme would be arbitrary without reference to the underlying crime, and this is what Judge Thompson pointed out. In other words, there would be no basis for imposing different punishments if solicitation were truly a generic crime that is completely distinct and separate from the underlying offense. Solicitation to commit murder is a more serious offense and is punished more severely than solicitation to possess a minor amount of marijuana, because murder is a more serious offense than minor marijuana possession. Solicitation in a particular case must be based, on the underlying crime in order to justify that difference. As the Fifth Circuit explained in the Peters case, Arizona expressly defines solicitation in the context of an underlying illegal act. It makes no sense to speak of solicitation in the abstract because it is a crime only insofar as it relates to an underlying offense. This ties into the case law that we cited in the brief that contradicts Mr. Murrow's argument that solicitation is a generic crime, starting with this court's holding in Portillo, which is that you cannot have a conviction for a preparatory offense without a jury instruction on the elements of the underlying offense. That necessarily connects the crimes for purposes of defining solicitation in a particular instance. As Portillo explains, solicitation must be viewed and considered in connection with an underlying substantive offense and cannot be based on undefined criminal conduct. The Mizrahi case from the Second Circuit goes into an extensive analysis of essentially the same thing and why you need to have a criminal object in order to supply the critical mens rea that makes solicitation illegal in a particular instance. The upshot of all this is that what you really have are different types of solicitation. There's not one catch-all generic solicitation offense. There are different types of solicitation, and the different types of solicitation are punished differently based on the underlying crime. You need to reference the underlying crime in order to complete the definition of solicitation in a particular instance, which then justifies the different criminal classification and the different punishment.
That is true that solicitation makes reference to the underlying crime, but the only controlled substance statute that we're talking about a violation of says nothing about solicitation. It is analytically possible to say one violated the solicitation statute when we look to an underlying criminal offense, but did not violate the substantive criminal statute, is it not?
I agree in the way you phrased it in that instance. I disagree that the only controlled substance law at issue is 13-3407. In this instance, solicitation incorporates the crime of possession of dangerous drugs for sale in order to complete.
Someone to commit murder, and it doesn't happen. Have I violated the murder statute?
No.
So why have I violated a controlled substance statute if I solicit someone to violate that?
The department isn't arguing that Mr. MURRO violated 133407. What we are arguing is that you need 133407 to complete the definition of his solicitation crime.
Okay, and I think everyone would agree that you need both statutes to come up with the conviction that we're talking about. But the excluded statute that really is at the heart of this appeal requires that he violate a controlled substance law. You just told me that I haven't violated the murder statute if I'm only convicted of solicitation to commit murder and nobody dies. So why have I violated the controlled substance statute if I'm only convicted of solicitation there?
Because the definition of excluded felony offense doesn't require a violation of the controlled substance law or the substantive controlled substance law. It requires a violation of a controlled substance law. And in this instance, solicitation becomes a controlled substance law when the crime involves possession of dangerous drugs, and the definition of the crime is only complete by referencing the substantive.
Solicitation is sort of a shapeshifter that can be a controlled substance law, it can be a violent felony law, it can be any kind of law, depending on the circumstances.
I think that's accurate, Your Honor. I think that's the point of Portillo. Finally, I want to talk briefly about voter intent. In Parsons, this court explained that the voters clearly intended to require consideration of the fact of a conviction for a controlled substance law relating, for a controlled substance related, again we use the word related just because it makes sense, a controlled substance related felony in determining whether an applicant is eligible for a card. Voters expressly precluded those who violated controlled substance law from having access to it as otherwise a controlled substance within 10 years of the conviction. Adopting Mr. MURRO's argument in no way furthers that intent. First, it ignores that his conduct was criminal only because it related to a controlled substance. He specifically intended a controlled substance violation. That's what made his conduct criminal. His intent to promote or facilitate a controlled substance violation. His argument is basically that he should benefit because his crime was uncompleted, notwithstanding that his intent obviously gives rise to the voters' concern about access to controlled substances. As the Fourth Circuit explained in the Medina Campo case that we cited in the brief, solicitation is an integral part of the drug trafficking process because it assists in identifying the market for illegal drugs. The overall purpose of statutory interpretation is to effectuate the intent of the voters. And that's really the point of the Rainey case and the Tunisant case that we cited in the briefing. It's construing the statute in a way that will achieve the overall purpose. Given the connection between solicitation and drug trafficking as explained by the Fourth Circuit, treating Mr. MURRO's crime as something other than a violation of a controlled substance law does not further the voter intent. This is what caused the ALJ and the Superior Court below to conclude that Mr. MURRO's argument would lead to absurd results. I'm almost out of time if there are any questions.
Thank you very much. Yes, Mr. Dean.
I think the use of the word shape-shifting law was interesting. I used the word the state would have this be a kind of a chameleon statute that becomes whatever offense it might refer to.
Isn't that the point of the Portillo decision, that to give it this kind of conduct or content in the individual case?
Portillo, I think, is sort of looking at this like this issue kind of from the other perspective, saying, how can a jury find anyone guilty of an offense if it doesn't refer to, because one of the elements of solicitation is that you have an intent to commit a substantive crime. It doesn't have to be committed, but you have to have that intent. Whether you know it's illegal or not, you have to have that intent. And that was obviously not included. That part of the definition of solicitation was missing from the Portilla court's instructions. They didn't explain to the jury what the intent, what the substantive crime was. So I think it's more of that case just failed to instruct the jury sufficiently on the solicitation statute.
Yeah, but isn't it a way of saying there's no such thing as a solicitation crime in a vacuum? Solicitation has necessarily appended to it a substantive crime.
Yeah, I think that's correct. Yeah, it can't be in a vacuum. It can't be just charged with solicitation. It does have to refer to something. But by referring to that something, I don't think it then becomes that something. That's why it's referring to it. It is not a controlled substance offense, or it is not murder when no murder has been committed. It is something else than murder. And this is something else than the violation of a controlled substance law. And it's not the first time this court has been here on this issue, really. If you look at Tellez and its progeny, is exactly, what kind of the conclusion I think the court came to in the 80s and 90s looking at this issue in that context, and which found that these are separate, that the preparatory offenses, all of them, are separate and distinct, quote, separate and distinct from the substantive offenses that they refer to, and that their mental and physical elements are not necessary elements of the underlying offense. So
Tellez would carry the day if the AMA said a violation of Chapter 34.
Yeah,
but it doesn't say that. It says any controlled substance law. That's where I'm hesitant.
But I think it's because, I think, Judge, if I may, it's because of the tendency to want to adopt the department's argument that we should be looking to anything relating to or involving a controlled substance. But that's not what it says. It says a controlled substance law. And fortunately, in the criminal code, we have a section, a title of this 1334, 3401 at SEC that gives us, this is where the controlled substances laws are. Here they are, right here in this section. In a completely different part of the criminal code, here's where the preparatory offenses are. They're under complete, so it's easy to
What about misconduct involving weapons, involving use of a firearm during the commission of a drug trafficking offense?
That would be a violent crime, which is also an excluded felony offense.
But would that be a controlled substance, violation of the controlled substance law?
No, certainly not. Any more than
because it's not in Chapter 34. That's your argument.
Right. Any more than an aggravated DUI would, because it may involve a controlled substance or relate to one, but it's not a controlled substance offense. It's a driving offense. It's not even in the same. It's in Title 28. These DUIs. It's not even in Title 13. But the same argument can be made about aggravated DUI that the department is making about here about the controlled substance.
A narrow path of logic that connects the dots in your eyes, but we're also under an obligation to avoid absurd constructions, and would we not be inviting such an absurd construction and absurd results if we said it's just fine if everyone holding this license wants to solicit the possession of dangerous drugs every day of the week?
Well, it's not the court is saying that. That's what the voters said. It's the voters who said.
No, what the voters said led to a 40-minute discussion about what the voters meant. So we have to figure out what those words mean.
Okay.
And I think there are two understandable views on these facts of what that law means. That's what courts do. We interpret statutory language. But one of the canons of interpretation that we use is we try to avoid absurd results. So if we were to say that the voters intended, I'm very wary of the use of that word, but because you cast it as a distinction between the court and the voters, I will say, do we really believe that the voters voted to allow certificate holders to conspire to commit murder every day of the week except Saturday and continue to hold that privilege? My guess is that if you asked an average voter, they would probably say no. That is clearly not the legal standard, and I won't engage in that analysis. But what do you have in the text to suggest that this isn't absurd?
2 points, Judge. One, these federal cases that the department has cited show us that you can actually include preparatory offenses. You don't have to, but you can. Some of them, in some of these statutes that we're dealing with in those cases, they said the substantive offense and listed out preparatory offenses. If the voters wanted to include preparatory offenses, they could have simply listed them, but they chose not to. And secondly, the only place in the AMA where we do have a clear, explicit expression of purpose of the Medical Marijuana Act is in Section 2G of the Prop 203, which states, as it did in, this was the issue in Maestas, when we looked at the purpose, the Supreme Court, first this court, then the Supreme Court, both agreed in Maestas, that that purpose is to protect patients and their providers from what? From people who might be a dispensary agent that has a prior criminal record for solicitation of a controlled substance offense? No. Protect patients and their providers from criminal and other penalties. Other penalties. Not just criminal, but criminal and other penalties. Now, I know the department would like to say, well, this has nothing to do with the penalty, but it's this man's livelihood. It's, it's not just, it is, and that's
Take
why.
about 30 seconds. and
Okay,
wrap up.
all right, thanks, Judge. So I think that, the drafters could have included that language, and I appreciate your question, but I just would urge the court not to give in to temptation to want to expand that specific language. It doesn't include preparatory offenses, and I think when it doesn't, it's not ambiguous. It just, there has to be a completed crime, a violation of a controlled substance law. And we have a section of the criminal code that has those laws, and it has to be something that's completed, not I started to, but then I stopped. That's
I'm
my.
sorry to take up just a couple
please.
more seconds,
Okay.
but I guess on these facts, one could imagine why your argument could hold water if we keep it just to this offense. But your position, I think, as you've conceded, necessarily involves sweeping away conspiracy, accomplice liability, solicitation, preparatory offense, attempt, as to any crime. And I have to admit, I have trouble seeing how, if one conspires to engage in a massive illegal drug enterprise, let's say we're importing tons of cocaine, and there isn't quite the evidence to suggest that the defendant actually possessed the cocaine, but clearly conspired and committed the overt act of supplying millions of dollars, that's okay under the excluded felony statute. And that's an inherent, necessary implication of your position.
I think that, I'd like to look at all of the preparatory offenses in a category of uncompleted substantive offenses. You're right. That's what I've been asking you to do. And I must confess, I'm sorry, I don't know which one, but one of these Tellez cases does specifically carve out an exception to attempt. And so perhaps conspiracy would be similar to attempt in that it is not a separate and distinct enough crime to be excluded. Now, that isn't my argument, but there is support for an approach.
But isn't solicitation the intersection of conspiracy and attempt?
The intersection of conspiracy.
Conceptually, that isn't. I mean, you're discussing with another person the preparation to commit an offense. Solicitation seems to involve threads of both.
Involving, because you're soliciting another person, so it's maybe an attempted conspiracy, so you could say. But I would and I appreciate those questions. I do think, and I'm sorry, I wish I knew which one. I want to say State v. Garcia, but I don't have that in my notes. But treat attempt differently in one of those cases, differently from solicitation and other preparatory offenses. So there is some support to your way of thinking about, isn't maybe there's a distinction between, for example, conspiracy and solicitation, that one is perhaps different and distinct, while the other one may not be. I would just, and I apologize, I don't know that, I can't give you the specific case. I don't have that in my notes here.
I appreciate your answer.
Thank you.
All right. Thank you very much for both your arguments, your briefing today. We will take this matter under advisement and issue a written decision in due course.
Thank you.
We are in recess.